Grigoris Bacharis, Verity Egerton-Doyle, Matthew Tweddell. Very warm welcome to Digital Markets Research Hub. We'll be discussing today a very high-profile issue with many unknowns and with many promising elements, namely the mechanism, different mechanisms of private litigation within competition law system, but with a focus on digital markets, and thus looking at Digital Markets Competition and Consumers Act, but also at other avenues as well. Some of those avenues are being proposed by some of our guests actually, and all have opportunities to reflect meaningfully and to comment. So it will be very interesting, innovative conversation, and I'm very grateful to all three of you for your availability. So maybe we can start with the first round being just an outline of the main of the situation with private enforcement in the UK competition law system. Grigoris, why wouldn't we start with you?
Right. Thanks, Oles, for inviting me. It's great to be here at your research hub, and I do follow your work and your YouTube presence. Right. So private enforcement in the UK, as many of your listeners will know, the UK is one of the most developed and advanced jurisdictions for bringing private damages claims in competition law. While there has been litigation ever since the 80s, and there has been a definite answer by UK courts that you can bring a claim for damages for competition law infringements as a private enforcement action. It has really been in the 21st century when those claims have substantially increased in both amount and sophistication. And this has happened in two steps. First, with the Enterprise Act of 2002, which first established the Competition Appeal Tribunal, and then with the Consumer Rights Act 2015, where the legislature basically permitted collective proceedings and even the possibility to bring opt-out proceedings. Parallel to that, we should not forget that the first important ECJ case in damages actions where the ECJ first recognized the right to bring damages, the Bacharis case, started in UK courts. And therefore, this shows that in the 21st century, there's been quite a lot of activity in this area. Now, after 2015, the litigation environment has completely changed. We have a lot of standalone claims which are brought both as individual and collective proceedings, and in a variety of areas such as finance, the digital domain, etc. Now, the reason why many plaintiffs prefer the UK as a jurisdiction to bring claims might have to do with the sophisticated London legal markets, with the existence of a specialized tribunal, the Competition Appeals Tribunal, that kind of integrates experts in its procedure. The development of those opt-out actions, which are somewhat unique in their sophistication and amount in the United Kingdom compared to other European jurisdictions. As well as, of course, very importantly, with the existence of a market for litigation funding and the ability of individuals and basically classes of victims of competitive infringements to bring representative claims and collective claims funded by litigation funder, which is one of the main impediments in bringing those claims in other jurisdictions in Europe.
Many thanks, Grigoris. Verity, maybe you can continue.
Yeah, of course. So, I mean, really from from the perspective of, what this all means for antitrust enforcement, I think we've seen a real step change since the Supreme Court's seminal decision in Merrick's versus MasterCard, which was a December 2020 decision, and it was a decision on the test for CPO certification, which really lowered the bar to certifying class actions. And what that's meant is that litigation funding has driven a real explosion in the number of cases that have been brought. Litigation funders and lawyers are actively searching for innovative and novel claims, and it's fueled a growth in standalone claims and in class actions, which has in particular really targeted the tech sector. There has also been a real push, and we've seen a number of cases where there have been multiple claims brought against the same kind of conduct, and we've seen carriage disputes. But really the scale of this kind of can't be overstated. So if we think about the statistics, back in 2016, there were 2 CPO applications. In 2017, there were none. By the beginning of 2023, there were 18 certifications and class actions applications. And critically, I think the really important thing is that if we go back in time, kind of pre-Merrick's, and certainly obviously before the collective redress regime, most of the cases we were seeing were follow-on class actions. The vast majority of private litigation in the UK was follow-on. And the huge change that this kind of availability of litigation funding has brought is that there's now really strong incentives for claimant firms, for funders to bring standalone class actions, which are obviously harder to prove, but where you have an opt-out class action available, where you can potentially bring a claim on behalf of millions of consumers, even if the individual harm to each consumer might be quite small. If you multiply that by millions, there's a lot of money on the table, a lot of money potentially to be paid out to claimants, but also to those in the funding ecosystem. So of those cases that we had at the beginning of this year, there were 16 of those were standalone class actions where the claimant will have to prove the infringement itself. And 2 of those were kind of hybrid that involved an infringement and also an infringement finding, but where they're looking to extend beyond that. I think the other thing that's really interesting and kind of excites me as a competition lawyer, kind of very interested in the evolution of the law in relation to regulating digital platforms, controlling market power, is what kind of infringement type we see these cases brought under. So historically, most of the competition litigation we saw was not for abuse of dominance, it was follow-on for cartel cases. Excitingly, I think, in terms of how we're seeing the law develop, of those cases I mentioned that we had in 2023, for the whole of the 2023 year, 12 of them were abuse of dominance cases. Only 5 of them were kind of cartel-based cases, and there was 1 that was hybrid. So it's really a huge change, and I think we'll come on to discuss in this session, what that means for evolution of the law and where we see kind of the center of gravity of the evolution of competition law, which has, in the UK and in Europe as well, really been sitting with the authorities and the review of the authorities' decisions by the courts. But actually, this huge explosion in private litigation means that we're going to see, I think, a lot of new law and a lot of the kind of the frontier of abuse of dominance developed in the CAT and in the UK courts.
Many thanks, Verity. Matthew?
Yes, I'm not too sure much is left to be said, but the importance of the Consumer Rights Act in bringing this collective proceedings regime cannot be understated. And I think that one thing that excites me, and that I think Verity was almost leading to there at the end, is this development of the law and these abuses that are being claimed by a lot of these different cases, the exploitative abuse that we see, that I suppose started out some time ago in this first wave of these excessive pricing claims, that was quite strict, quite narrow, whereas now we see a lot of different claims kind of alleging various different types of economic activity to fall under this this head of loss that we might not otherwise have seen had it not been for the kind of collective proceedings regime. So that was the only thing I wanted to kind of emphasize. I think so much has been said already, but definitely the development of the law and some of these types of claims is also a factor that we're seeing.
Indeed. And the next question, as you have all noted the trend that we have more cases, and with more cases, we have more opportunities to categorize them by different criteria. I understand that it's a little bit premature, that it's evolving very rapidly, and all the opinions would be rather subject to the testing how in temporal dimension, how reliable these reflections would be. But your personal reflections, intuition based on observation, is it possible at this stage to say that the trend is towards more technicalization, and you have to provide more technical underpinning to your claim, or it's rather reference to broader societal interests, more intuitive, easy to comprehend by non-experts? Do you see any kind of any interdependence between the speed and the depth of the cases? Is it getting more pro-claimant or pro-defendant? Any signs of some possibilities to categorize these cases in the future, at least? Again, let us start with you, Grigoris.
Right. So I guess those are multiple questions. As to first the categorization of cases, I would just want to agree with both Verity and Matthew, that it's been alleged at least that there's been quite a lot of, let's say, more creative cases that are brought to the Competition Appeals Tribunal, the CAT, in the sense that they cover aspects that might not be thought of as of stricter sensu, or in a narrow sense, competition law, and they touch on aspects of privacy law, environmental law, even consumer product liability law, or consumer law. Therefore, it seems that there's many technical aspects that touch upon other legal fields as well, currently in front of the CAT, which might complicate even further, for instance, litigation in this area, and might necessitate or require coordination with regulators in other fields, which again, this might become very technical very quickly. At the same time, as to your second question, I do believe that expert evidence is absolutely central to the procedure before the CAT, and it is often what both the trial merits revolves around, as well as it's very relevant to certification proceedings. And lastly, the CAT has been quite creative and quite active in case management of cases. It's given that it's faced itself with a huge load of cases, it's very important to note that the CAT has tried to creatively split the trial in some mini trials, or to create a segmented sequential trials as well. So it's been quite creative in that sense.
Thank you very much, Grigoris. Verity?
Yeah, I mean, maybe Matthew, you write a reply after this. But I think, from my perspective, and I'm usually more on the defense side, certainly it does seem a very claimant-friendly environment, the CAT, insofar as certification of claims goes. And I think that's really all we actually know at the moment is the CAT's attitude to certification. But certainly from the perspective of certification and being able to put these claims together and run them, and involve a lot of lawyers in defending them, and of course bringing them as well, the bar is from our perspective very, very low. So I think what we see is a real mix of claims. I mean, if you look at the profile of the cases that the CAT has, especially in the digital space, I mean, there are a good number of cases which are really picking up on European Commission or CMA investigations and focusing on often slightly broader conduct than the conduct that might be the subject of that investigation, but kind of going over relatively well-trodden ground. And I don't think we can say that those claims are novel or really out there. Of course, exactly what happens in the administrative process might mean that we do see the law made in those claims. So, for example, the CMA just 2 weeks ago actually closed its investigations into Google in relation to Google Pay, and a similar investigation into Apple in relation to the App Store. That there are claims, I think Matthew might be involved in one. There are claims in the CAT that relate to that conduct, and so now we're probably going to see that develop through the CAT, of course, unless the cases settle. So there is, there's a rump, a really significant rump, which are cases that do are not follow on, but kind of cover conduct, which is the subject of authorities' investigations. But there's also, and I mean, my understanding is that this is a deliberate choice by litigation funders to bring a kind of mixed portfolio of cases, of mixed prospects of success and mixed risk. There are also some cases that are really, quite out there, we would say, in terms of pushing the boundaries of competition law. Grigoris has already kind of touched on the fact that they might bring in elements of privacy law or of consumer law. And actually the way that the UK litigation system is set up is because this test for certification is quite a low legal threshold for competition actions, whereas there's a higher threshold set for other kinds of cases. That has really incentivized claimants to try and fit things, squeeze things into a competition law infringement. And I mean, of course, that is competition law has always been there, and it's something we've seen, over the decades, that competition law often kind of steps in and can fill the vacuum where there's perhaps a perceived kind of gap in the law. So there are some really interesting and quite, I would say, probably speculative cases before the CAT, which are pushing the boundaries of what you might consider to be competition law. And what we've seen is that, really in that first phase post the Merrick's decision in 2020 that I mentioned, there was really an anything goes approach in the CAT. I mean, I don't say that in a derisory way, but I think a deliberate decision that, that the government obviously wanted this regime to be a success. And I think the CAT took its marching orders and said, the Supreme Court's given us this direction, and we should let these cases be certified and let them come on. We've seen then, after the certification of a significant number of claims, a bit of a more restrictive approach in some of the cases, in the Gormson case against Meta, in the iPhone batteries case, in the interchange case, where we've seen some challenges to certification. But interestingly, still, even where certification is not granted at the first stage, what the CAT has done is sent the claimants, the class rep, away to get them to redo their homework. And I don't know, Matthew, if you might have some reflections there on kind of the economic evidence, because in particular in the Meta case, I think the economic evidence was really critical. And they came back a second time, new economic experts, and they got certified the second time. So I think, the pendulum swung in one direction, the pendulum swinging has swung back perhaps slightly more in the other direction. And then, there was a critical Court of Appeal decision in Forex recently, which I think perhaps sees it swing slightly back the other way. But, we're still at the very early stages of this regime. And all I've been talking about now is certification. The first step, can you bring a claim? We're really not going to know for some years how the CAT's actually going to approach the question of liability, and then, of course, of actually awarding damages. And so, there's a lot to watch and a lot that we still don't know. And if you talk to, interestingly, talking to lawyers in the US, where there's a very active class actions regime that's decades and decades of experience under that. I think, you talk to them and you can see that where we are in the journey in the UK is probably at the early stage. In the US, there's actually, more hurdles at an early stage. And I'm not sure if we might kind of move back in that direction after a few years of this, because it was December 2020 Merrick, so it's less than 4 years now since that decision, and there's a lot has happened.
Thank you very much, Verity. Matthew.
Yes, as you probably all suspect, and particularly Verity, I might push back on the pro-claimant environment that Verity suggests. But to kind of start with the, I suppose, is the law or this area being driven by kind of society, or is it technically kind of charged? I think actually it's a bit of both. So, a lot of these claims, even the standalone claims, are still driven, or at least based in part on some sort of regulatory decision. And what we are seeing as well, actually, is that it won't even necessarily take a regulatory decision to kind of ignite, a prospective claim. It could just be a statement of objections or something like this. So in that sense, you'll have obviously the competition authorities are probably looking into what is, societally driven. So there's definitely that impetus there to some extent. But on the same hand, there are cases that kind of might take some inspiration, but are largely, very deep thinking about the technical areas of law. I think the ad tech stuff you could definitely say is whilst it is kind of society driven and there's a lot of investigations around that area. So some these are standalone cases, and I think they're really contemplating how these complex systems really engage with competition law. So I think in that sense you could say that there is this kind of technical kind of impetus as well. I think as to how deep the competition hearings are, I think at least relative to other types of civil claims, they're very deep. And I think you see that with the fact that at least in the UK we have this specialist tribunal, that the Competition Appeal Tribunal, which is comprised of not only lawyers but also economists. And yes, as Verity was pointing out, economic evidence plays such a huge role in these cases. So it's inevitably going to be a very deep and long kind of process to get to the bottom of what's really going on. I think in terms of maybe the landscape and how you could characterize it as pro-defendant or pro-claimant. I don't know if it's necessarily right for me to say which side I fall on, but I do think the opt-out regime in particular was a very important mechanism, and there are, which I think we'll get to, I suppose, ways you could classify that system as being quite pervasive, but I think rightly so that they're pervasive. And then I suppose in addition, the rules of quantification, which we're also going to look at, and how compensation is reached in competition law, again, can be viewed on one hand as being pervasive, but again, I think there's all very good justifications for this, and if they weren't that way, then what you have essentially a barrier to access. So it is a pendulum swing, and it's important that we find the right balance. And I think at times you will get cases that are brought on the one hand that could be classified as being somewhat speculative, but I suppose time will tell as to whether they are, and it's important that the law finds its way, and that we really end up with the law developing in the correct way, and that victims of competition harm are rightly vindicated.
Thank you very much. You all published or have written really insightful papers, and I wanted to use the opportunity of today's meeting also to ask you to highlight the key messages, but also to invite each other to comment on those messages as well. The final question before we will reverse the order and ask you, Matthew, to present your paper first. But the final question on this broader kind of outline is how predictable the situation is. Are we currently, Grigoris, at the stage where it's like complete terra incognita, or we can somehow anticipate the outcome of the cases? And maybe for you, Verity, and you, Matthew, how do you communicate these expectations to your clients? Do you feel the confidence about the plausibility of winning, losing your case, or it's very unknown territory? Grigoris, let's start with you again.
Right. I think, of course, practitioners will be better placed than me to answer this question. But saying that, and given the remarks by Verity about litigation funding a mix of different cases, for instance, in collective redress proceedings, we can see that some of them might have, prospects, very realistic prospects of success, or at least settlement, whereas others might be a bit more novel. And part of why they're brought is, to kind of advance our knowledge about what's happening here, as to, and it's quite significant legal uncertainty. And again, we can't overstate, the novelty of, both collective proceedings and how different those civil claims are compared to other types of civil claims. Given that I'm a private lawyer as well, and an academic in private law, I think it's very important to emphasize for other private lawyers as well that competition law is spearheading a very big change in how litigation in civil claims is shaped. A change that kind of more closer aligns our system more closer to, say, US law with its class action proceedings. And therefore, it's quite important to take stock of developments, because what happens in competition law might have a big impact in other areas, not just of regulatory private law, but general private and tort law. Yeah.
Thank you very much, Grigoris. Matthew, I propose you start and then Verity you, because then the next round will be a question about your paper, so that you have at least some time to breathe. So please answer, and then Verity.
So when it comes to, I suppose, the client's role and you know, expectations, I think the only thing I can really say is that, you know, some clients naturally are more proactive than others, and might want to get involved and offer insights that others might not. But I think, you know, each case, you know, we take a view on, and we express that view. And you know, if a case didn't, for example, have any legs, and I don't think the client would be there anyway. So I hope it doesn't sound like a cop-out answer, but there's not much more to it, at least from my side, than to say that we're confident in you know, in the area that we're in and what we're doing, and I think our job is to really advise on that, and whether or not you know, where the client stands on the facts of the case at hand.
Thank you very much, Verity.
Sure. So, I mean, in terms of advising clients, I mean, first, maybe a bit cute to say, but you know, it's pretty easy to advise clients what's going to happen on certification, because as we've discussed, you know, most of the time we say your claim's going to be certified, or the claim against you is going to be certified, because if not immediately, if there are some gaping holes in it, probably they're going to get a second bite of the cherry and come back, and it will be certified, albeit it could be in a slightly different form to the form in which it first appears on the claim form. So that bit is relatively straightforward from a kind of defence advisory perspective. Of course, there's many nuances. But then when it comes to kind of advising on the substance and, you know, exactly how, you know, will there be a finding of liability? That is, I think, a lot more difficult. And that's for a number of reasons. It's, you know, first of all, as we've discussed, a lot of these cases are, and even those that are based off, you know, ongoing or recent competition investigations by the Commission or by the CMA, even those, many of those are kind of at the frontier of abuse of dominance enforcement. And, you know, even if you end up with decisions, if you think about some of the decisions from the Commission, you know, they're challenged through the courts. They don't always survive through the EU courts in the way that they came out from the Commission. Often they don't. And so, you know, actually advising on, there's one question of, you know, what do we think is the correct interpretation of the law? What do we think is the correct legal position? I mean, that in itself is a really hard question. And, you know, there's many very smart people who spend a lot of time thinking about that. Then you've got the second additional element of, you know, the uncertainties of litigation. And I think it's fair to say that some of the decisions out of the CAT, especially on, you know, appeals of Competition Act 98 infringements, have gone in directions that not everyone necessarily expected. And so it can be really difficult to advise on that. But then I think the third element, which we haven't really covered yet, but which I think is really, really critical, is of course settlement. Because a lot of these cases, you know, may not run all the way to a finding of liability, and it's very common for litigation to be settled. So I think that's a really important factor. And when we think about the huge number of cases that have been certified, you know, it's very unlikely all of those will go to a full trial and to a finding on liability. Even if they go to a finding on liability, they might likely then be settled when it comes to the question of quantification. So I think that's a very important element where we've only, you know, we've only seen I think 2 very small settlements so far. We've not seen a kind of proper practice of settlement evolve in the CAT. And then one final remark before we move on is I think it's important to think about it in terms of, and Matthew, you have more insight into this than me, but in terms of, you know, what is driving the strategy and, you know, what clients want to get out of it. I think that differs depending on who it is, who's obviously the litigation funders want to get paid. But in terms of, you know, there are some class representatives who are just an individual who can be named and be the name on the claim. That there is a growing group of quite kind of activist class representatives who might be acting on their own or on behalf of, lobbying organisations, policy organisations that have a particular viewpoint that they want to push. And actually, the class action in the UK could be just one element of a much broader, bearing in mind these are global markets, a much broader global strategy that might involve complaining to competition authorities over the world, putting pressure in different kinds of litigation in different jurisdictions. And actually from the defence side, that's one of the things that we find to be the most challenging, but also, the most interesting and rewarding to advise on is how you can advise on this piece of litigation in the UK, but really in the context of potentially having multiple antitrust investigations, different authorities, different parts of the world, as well as litigation in a number of different jurisdictions. And I think what that means is that, class representatives might not always bring the claim thinking that it's going to necessarily succeed in the UK, but it might be part of a broader push to try and achieve some change in policy or change in direction that sits alongside, the Digital Markets Act, the DMCC, which we're going to talk about, competition law all over the world, and it's just one lever to pull in that kind of global regulatory strategy.
There is big temptation to ask several issues. I will not be asking about only one: settlement. Do we document it somehow? Do we know at least? Can we again categorize? Can we, out of the cases which have been settled, is it a completely confidential information, or there are some public recording at least of the signs of the hints? What is being settled? How broad the coverage of the settlement? Can it go beyond the specific subject matter? Are you aware, or it's completely something which is beyond the closed doors and it shouldn't be even public? Whoever wants to reflect upon this. It goes beyond the topic of our conversation, but if there is any out of top of your head.
I suppose to my extent, I think the settlements are, not publicly available to the ones that we're talking about. But I mean, in some ways, to get to settlement, a lot has happened in the public domain. So you do, benefit a lot from seeing, exactly what's panned out to perhaps get to that settlement. So I think there's definitely a benefit to be had there. But other than that, at least in my experience, it's a bit of a black box.
Okay, so let us, yeah.
Yeah. Well, the only thing the only thing I was going to add to that is just that I think what is different in CAT litigation and under this regime than under other forms of litigation is actually the court is very involved in the settlement process. So it's not, and I think this is what you're getting at, Matthew, with a lot in the public domain. It's not a matter of the class rep and the defendant can just agree a settlement and that's the end of it. The CAT has to be satisfied with the settlement and satisfied that adequately protects the interests of the class members. And so that does mean, I think, and I think that's why there's first of all scope for significant practice to evolve in settlement. It's not obvious that the CAT is always going to approve a settlement, and I'm sure the CAT will not always approve settlements that are agreed between the class rep and the defendant. But secondly, it means you do have a lot more in the public domain, as you say, Matthew, to get to that point. And as I said, we're only at the very beginning, but I think that's an area where we're going to see a lot of developments over the next few years.
Amazing. Let us revert to the papers. We have 3 papers. Matthew, you come up with a quite innovative proposition about managing or the future development of damages. Can you please elucidate the key messages?
Yes, so this kind of stems from a paper that I've written with my colleague and friend Konstantin Pantelidis, and essentially the normal way that damages are measured, at least for competition law grievances, is called compensatory damages, which essentially just measures the position that you would have been in but for the competition grievance. So it's a loss-based calculation. English law also recognizes what's called restitution, which doesn't look at the loss but looks to the gain. So how much has, say, the defendant made out of breaching this law that it otherwise wouldn't have? So 2 different ways that you're looking at quantifying something. In competition law to date, there hasn't been ever an award on the basis of restitution. But as I said, it's a common area, or it's a common way to to measure damages in other areas of law. Now, the reason what kind of intrigued us both to look at this in a competition law context was for a few reasons. One, the legal picture when it comes to this is actually quite unclear. We have one Court of Appeal decision that flat out said, no, you can't have it in a competition law setting. We can't award restitution. And then we have another Court of Appeal decision that said, in actual fact, you probably can, though it wasn't a decision about actually needing to do that. And then we've had various utterances in the CAT that kind of at times seem to say, yes, restitution is on the cards, and then at other times seem to say that it isn't. So I think the starting point for us was just kind of legal curiosity as to, well, what actually is, the status of this, and is it possible to bring this claim? So that was the first reason. Then the second point is, I think in the competition law context, it could be very valuable, and I would not be surprised if it does play a role in future cases, particularly in the digital markets context. For example, if you take, say, Gormson, as we were speaking about earlier, that's a case about the unfair use of data. So if you're going to quantify exactly, how much has been lost as a result of Meta allegedly using that data, it's quite a difficult exercise. But whereas if you were to say, and also just to slightly back up, so that claim is an exclusionary claim, and it's being brought under an unfair trading terms claim. So to actually quantify that on this loss basis is quite difficult. Whereas if you were to actually just look at the gain that perhaps Meta have made, and indeed in the CAT judgment, this is one of the cases where they almost suggest that this might be something that they're going to bring it on that basis. But if you look at that claim, quantifying it via how much has Meta gained would, at least in my opinion, be an easier way to go about it. One other final point as to why it's important. Competition law claims are notoriously difficult to quantify anyway, and particularly in the context of collective proceedings, where you have more and more claims, and it's just a bigger issue. As we said earlier, economic evidence also plays a very key role in competition law claims, and when you have two parties, both with their economic experts, in the adversarial context that we have in the UK of our legal system, it basically amounts to quite difficult ways of actually getting to the loss. That's not to say that some of these issues wouldn't arise in the case of restitution, but in certain circumstances, it might just work out to be better. So this was like the impetus for looking into as to whether it should be a good idea. And then I suppose to just kind of summarize what the position is, we make a claim that it does seem that there is a legal case to say that you can bring a claim for restitution. And this is essentially based off, one, the fact that the competition regime, the UK competition regime, seems to permit, it just allows for damages, and restitutionary damages are a form of damages. There's no kind of express wording within the Competition Act that would suggest otherwise. So there is a basis to bring that claim. And then you move into the various rules that govern an award of restitution, which, and this is an important point, it's not to say that an award of restitution is not unbounded. There are common law principles that govern its availability. The three, to just quickly run through them, are: one, compensatory damages have to be inadequate. The second is there's normally needs to be some sort of cynical behavior at the center of this. And I think that gives rise to lots of very interesting legal questions, particularly in competition law, because it's an objective abuse. There's no intention required. It's an interesting legal question to say, well, to what extent do we need to think about cynicism to the extent that we do need to think about it? I think we could probably make a strong case to say, for example, a cartel is a cynical act, people gathering together to specifically raise prices. But then I think there might be some other abuses that are more nuanced, where perhaps companies don't necessarily know exactly what they're engaging in, but they just happen to have triggered competition law in a various way, where maybe that cynical element wouldn't trigger. And then there's a final point to say about, there's a bit of a debate about whether restitution is available for non-proprietary torts versus proprietary torts. To cut a long story short, again, we think that there's a case to say that competition law, which is breach of statutory duty, a non-proprietary tort, should still be made available should still be possible to bring a restitution claim for that in that context. So that's a very, very kind of quick summary of the claim, or of the case, sorry. But there's lots of interesting legal questions. It's a contentious issue for sure, and it's by no means resolved, and it's a very early stage to think about this. But I think particularly in digital markets, it will play an important role in the years to come.
Thank you very much, Matthew. Grigoris, Verity. Now, if I can ask you either to reflect upon this idea, or maybe to ask questions, clarificatory or substantively challenging questions to Matthew, and then we'll revert to other two topics as well. Grigoris.
I found the paper really fascinating, given how it deals with the intersection between private law and competition law. And I think it's the main argument is quite convincing. I'm convinced that, by Matthew's and Konstantinos' arguments, that disgorgement could be a useful tool in the toolbox of a claimant. At the same time, I guess my main reservation, or at least where I would be a bit more skeptical as to this, would be how you would go about arguing this. In my mind, at least this distinction between proprietary and non-proprietary torts is quite clear in the case law as to when competition damages, when damages, compensatory damages versus restitutionary damages will be awarded. Therefore, I think there should be a case that kind of changes precedent in this area. In order for this to happen, it would be hard to argue that under the current law it would be possible to give disgorgement. Another issue to award disgorgement. Another issue would be in the paper there is a discussion about the aims of competition law and competition law damages as opposed to other areas of tort law. And I was wondering, I guess this is more of a question, whether the argument cuts specifically across this area as opposed to other areas of tort law, that where there are specific competition law reasons for why we should award disgorgement here, as opposed to having a principled stance that cuts across all of tort law. And I think you could actually have a very good argument about doing this, given that there are clear pronouncements that in this area deterrence is as important, or at least is the same level of importance as compensation, which seems to kind of stray away from the general tort law paradigm. But that would mean that in this area we have a specific kind of tort that aims not just at compensation but also at enacting public policy or deterrence. And I think we should be really clear about this, because that would mean that other tort law principles might not apply in this area. So we should create some kind of special category of tort law where it's got its own unique kind of like tailor-made tort rules or damages rules. And I think this is quite a far-reaching argument, but it's novel, and we should. It's kind of something that needs to be discussed. The last thing is that I wanted to ask Matthew, maybe a bit more directly, is how could a claimant prove that compensatory damages are not adequate and we should switch to restitutionary damages? What kind of exact argument should be made in that regard? Yeah, that's all.
Thank you very much, Grigoris. Verity?
Yeah, I mean, to my mind, the big question is about who receives the payout essentially, and so who determines what has to be paid and who actually receives that money. And I think the touchstone really of the compensatory system is that it's only the individuals who suffer the harm who receive the payout of damages, and that damages payout should match the harm that they've received. I think moving away from that in this context is really, really difficult, especially, we already know that there are many disputes over pass on. Indeed, that's been one of the big issues in competition litigation going back decades, is the extent to which the kind of increased price was passed on downstream. I think that, bringing in a restitutionary concept, I think makes that element very difficult, and I think muddies the waters significantly. The second question is then, if you say that the compensatory principle isn't enough, that doesn't, I think I would say that that's the role of public enforcement. It's the role of public enforcement to both generally and specifically deter infringements. And, that's exactly what you see in the penalties guidance of the Commission, of the CMA. There's a big focus on deterrence. I mean, I can see that people might say, well, of course, if an authority can only bring so many cases, they're resource constrained, there will be infringements for which, where people get away with them. But that's also the purpose of having of the general deterrence element of the fining system, and also I think it is right to have a public authority choose which of those cases to bring, in my opinion, rather than to have have private claimants be making those decisions and potentially getting payouts. I think having a restitutionary system where a private claimant could get disgorgement where they haven't suffered loss, I think raises a number of really kind of complex, and it could create a number of perverse incentives which would be actually counterproductive.
Thank you very much, Verity. Matthew, please reflect to this comment.
Yes, yeah, thank you. And very absolutely justified comments, in my opinion. I think just starting with Grigoris, so I think on the proprietary point, I do agree with you there. So in my opinion, I think the law is actually quite unclear there. And I think there is a case to say that, or at least the courts have showed a willingness to be open to awarding restitution, whether or not in competition law, but at least for some sort of non-proprietary tort. And without getting into all the kind of legal detail, I think it's a very unclear area that I think when spelling it out and pulling it all, I think there is a route through. But I do agree with you. There's going to need to be some sort of appellate authority, and a case is going to need to be taken to that level, and we're going to need some sort of clear decision. And that might be a bit of a stumbling block, because that's not, it's hard to kind of, I suppose, as a claimant to, want to litigate a case on the basis that you're entering new territory. But notwithstanding that, I do think there is a case to say that it's available. And I completely agree on the deterrence point. I've been, quite careful to, in the paper at least, to really make sure that competition law doesn't spill over too much in or depart too far away from the principles of corrective justice that govern private law. And I think, in my opinion at least, that is really the center of everything. And it's not for one moment that I want to essentially say that restitution should be available unfairly and should provide windfalls to the claimant that the other way shouldn't have. I think, just to backtrack, that the reason why restitution is there in any event is actually to fulfill a corrective justice role, in that there are certain sets of facts that give rise to a situation where compensation is just impossible, but everybody can see that there clearly has been harm suffered, and that's when it comes in. So I think that's my route back, at least in this argument, to say that this is why we should have restitution in a competition setting, because some of these things that I'll get onto, and I think chimes with your third point, Grigoris, about inadequacy of damages, but quantification, pass on, as Verity mentioned, there's many things that can really put the claimant in a position where they've clearly suffered a loss, but all of a sudden, because of the difficulties in quantifying everything, they just can't prove it. So and I think, you know, it's hard to iron out an exact set of facts, but I do think difficulty in quantification can certainly serve as a reason as to why compensation would be difficult. You know, pass on, I think, is an issue that's, you know, well known by economists to almost be, you know, unresolvable to a certain extent. It's a really difficult area to think about. So again, you can have these very complex issues of pass on, and you know, what happens then? You know, is that enough to just say there is no claim? But if we can all see that harm's been suffered, then, you know, I think that's when restitution would jump in. So far as Verity's observations go, and again, this is what I'm trying to say about corrective justice, which I hope answers them. I believe Verity was, I suppose, highlighting that who should determine these awards, and, you know, how much they're going to be, and so on. And my answer to that is, you know, we're still in the realms of corrective justice, and it's just the same as compensation, whereby, you know, the court hears the arguments and it does the best to determine the loss. You know, that would apply exactly the same to a claim for restitution. It, you know, hears the arguments and just determines the gain. And I do then, you know, can fully take Verity's observation that if compensation is not enough, should we then move to this public law realm, which is kind of where Grigoris is going, and I can completely see that justification. But I think what I'm trying to say is, you know, private law has many different routes of quantification, and that by extension they should be available to competition law. There's no reason to suggest they shouldn't, so long as they chime with the various principles that govern them. And, you know, not to sound like a broken record, but it is this point about corrective justice where the facts of a situation in a competition law setting are just so difficult to determine the loss that I believe something like restitution should actually be available to help, you know, ensure that claimants are vindicated properly.
Many thanks indeed, Matthew. Let us now revert to the second paper, which we have it in almost alphabetical order. Grigoris, can you please present to you your co-authored piece to us and the key messages?
So this paper kind of ties quite well with Matthew's paper, in the sense that it kind of discusses the availability of, you know, alternative remedies aside from damages claims in private enforcement, compensatory claims in private enforcement. I have co-authored this paper with John Kwan, who's at the CMA. He's an assistant director at the CMA. And it deals exactly with this issue of basically, you know, the interaction between private and public enforcement, and whether public enforcement should take a step in basically awarding redress directly to victims of competition infringements. Thus, instead of, you know, victims suing in court, they will get, for instance, a part of the fines, or, you know, they have to resort to a fund set up by the regulator, the CMA, and the assistants to do that. So this kind of ties to a broader literature on so-called regulatory redress, which kind of ties well with, you know, some of the perceived deficiencies of private enforcement and damages claims. Some of them mentioned by Matthew. You know, for instance, the fact that quantification might be really complicated or really tricky for many claimants, or the fact that litigation funders have a dominant role in this area, which means that if some category of victims don't have such funding, they will be effectively excluded from claiming damages. And more broadly, it has to do with a certain misalignments with, you know, public enforcement. That is, private enforcement damages claims might not pursue the same, you know, cases that the public regulator would pursue. And even more than that, there might be some conflict between, you know, damages claims themselves and what they aim to achieve and what the public regulator aims to achieve. Therefore, as an alternative for that, you can make a positive case for, you know, creating those novel consumer or generally regulatory redress techniques, or introducing them. And again, the positive case has to do with access to justice. If some victims are effectively barred from suing for compensation, then it's not a big kind of step to say that the regulator should be the one that steps up and awards compensation to them. At the same time, having a regulator like the CMA use part of the funds to compensate victims, we claim this basically furthers their own competition objectives. It kind of resets the situation by giving compensation to victims, basically returning back to the original market conditions. But also, it's a very effective tool for competition advocacy. It makes the regulator, the competition authority, more popular by handing out compensation. And lastly, and importantly, ties very well with a broader literature on responsive regulation techniques, which in regulatory studies are kind of like the new kids in the block, in the sense that they argue for a more flexible approach. Instead of using this crime tort model with fines, which is perceived as rigid, we use the regulator to kind of create this tripartite cooperation between victims, infringers, and the regulator, and allow for more flexibility in how they deal with that. Now, another thing I want to add is that in this paper, we develop a typology of those types of regulatory redress. It's not all the same thing. They can range from compulsive restoration, that is from the regulator ordering an infringer to provide compensation to victims, but also compulsive disgorgement, again, to tie it with Matthew's paper, that the infringer is ordered to disgorge any gains from the infringement. But at the same time, we have so-called voluntary redress schemes that can be agreed between the infringer and the regulator in exchange for a fine reduction or as part of binding commitments. Lastly, another interesting technique is the so-called fair funds, which are used by regulators in the US, most prominently the SEC, where the regulator is empowered to add fines from infringements, from findings of violation, to a compensation fund, and then give those fines to victims directly. Now, all those are very different techniques. So in this paper, without going into too much detail, we develop a typology of those, and we try to kind of like chart them out basically based on the goals that each of those techniques aims to achieve, whether it's more about deterrence, more about compensation, and whether it's more about a voluntary participation by infringers or alleged infringers or compulsive methods. And then we analyze a certain number of cases, both in other jurisdictions and in other areas of law. What's interesting is that we've got such techniques, such regulatory redress techniques in other areas of regulatory law in the UK, most prominently energy law, but also securities law. We've got them in the US, where they are very prominent, and they kind of are filed under the rubric of public compensation. And lastly, we've got some first steps towards this direction in the UK competition law field as well, prominently in two cases regarding the flaurocortisone market, where the CMA accepted a payout to the NHS as a reason to reduce a fine. So basically, it seems to be that there is a category of cases where those voluntary and non-voluntary redress techniques might be very useful, if not as a substitute, at least as a complement to private enforcement. And at the same time, we shouldn't be too hasty in basically, arguing for them, because it might be quite tricky. At least the compulsive methods of providing this regulatory redress, it seems clear to us that they need a legislative reform. But at the same time, the CMA should make use of more voluntary redress under its current, regime. And last thing, and I finish with that, the DMCC bill introduces those so-called enhanced consumer measures in consumer protection law, not in competition law, and has issued in July some draft guidelines on how they're going to go about implementing them. So we can see that there are developments in this area, at least in the consumer protection side, and we don't see why these same techniques wouldn't be very useful in the context of competition law too.
Thank you very much indeed, Grigoris. Let me ask if you have any questions or comments to Grigoris' paper.
Yes, firstly, fascinating paper, and particularly the typologies I thought were so interesting and just so clearly laid out that you could just immediately, get to grips with what you were saying. And I really did enjoy reading it. And not to mention, I think what's actually interesting is between my paper and yours, we both highlight the issue, and obviously we're just kind of facing in slightly different directions. But it's great to know that that there is an issue, or at least you think there's an issue. So yeah, it was really, really good. I think there was just maybe 3 points that I was curious to just hear. So I think in one section you talk about the preclusion of private claims and to what extent private claims should be precluded. So I'd be very curious to just hear you just expand slightly on that, and exactly how, if some of these, or I suppose if public enforcement were to take on this role in a larger extent, exactly what that would mean for private enforcement. Secondly, I think one point you make as well is about the tension between leniency applications and private damages actions. I suppose I was wondering, is there an argument not to say that that tension might actually show that private enforcement is actually doing a good job, because it shows that defendants are cautious of these actions, and therefore maybe private enforcement's playing that deterrence role. So I think anything to maybe remove that. I was wondering about the effects, or the good effects that private enforcement is already having, and how we could protect that to the extent that you would agree. And then lastly, I think one of the points you make is how funders kind of end up almost being the arbiters of bringing these cases, and I completely get the sentiment. But I was curious to know, or maybe hear why exactly, are say competition regulators placed in a better position to be the arbiters themselves? And I think there's probably some obvious answers there, but I'm just curious to maybe hear that view. I suppose just wrapping up my overall view on this is that I do think the best course of action is a holistic view needs to be taken where both private enforcement and public enforcement are complementing each other and proceeding forward in the strongest way, and coexist together, all in aim to ensure that claimants are able to, their rights are vindicated. So I suppose that was just my overall sentiment on it. But I really enjoyed the paper.
Thank you very much, Matthew. Very good.
Great, thanks, Matthew, for those comments. So starting with the first one, as to the preclusion of private claims, I don't think either me or John have a very clear position as to this currently. Looking at other jurisdictions, it seems that in the US, where those techniques and regulatory redress models are most advanced, generally they don't preclude private claims, even though in the US, those regulatory redress techniques are specifically aimed at deterrence. So, the most far-reaching regime doesn't even go as far as precluding those claims. So I think it would be quite hard to argue, that there would be legal preclusion of claims, given again that it would create issues as to access to justice, etc., for claimants that would do that. However, de facto, it might be, it might lead to the preclusion of certain claims, given that claimants will lose quite a lot of the, appetite for bringing a claim that they know that a regulator would do this to them for free, essentially. As to leniency applications, there is quite a big empirical dispute about whether damages claims and how disruptive damages claims are to public enforcement, and specifically as to Linux applications. I think the academic literature, at least, is not quite settled yet. There seems to be quite divide as to whether the impact is so negative as to that. Whether this is an indication that private enforcement does a good job is thus contentious. I guess the one way to think about this is whether private enforcement does a better job than public enforcement. Whether not if it just does a good job, but whether it's better than public enforcement. And let's not forget that private enforcement is quite new in Europe as a whole. We've relied a lot on public enforcement techniques in the past, and there seems to be quite a lot of trust into competition authorities being able to do their job properly in enacting the aims of competition law and achieving deterrence. And this, again, I guess, ties with the last question of whether we should trust competition authorities to do that job instead of litigation funders. There are some statements in the case law as well that seem to indicate some skepticism about the motives, the profit motives of litigation funders, and whether they are the ones that should drive the development of case law. And given how delicate some policy issues are, and the broader picture of increasing market concentration, it seems to be not the best choice to leave this just to private litigation, and at least create some room for public enforcers as well to be able to develop policy and increase the competition advocacy role through the introduction of regulatory redress techniques such as voluntary redress schemes, or even more compulsive remedies.
Many thanks indeed, Grigoris. Let us now move to the third paper, and maybe we'll combine some questions which are relevant to all three papers. Verity, can you please summarize to us the key observations about the MCC Act and some other developments which you are interested currently?
Yeah, of course. So, I mean, I think from my perspective, I don't know, Olis, if you want me to talk about the paper on public and kind of the balance between public and private enforcement, or move straight to the DMCC. Maybe just briefly on the paper. I mean, it is now a little bit old, and the pace at which this space has been evolving means it feels quite out of date, although it was only published less than a year ago. But I think maybe just a few observations off the back of Grigoris's paper, because I think it picks up quite well. So what we looked at in our paper is kind of the interplay between public and private litigation. And I mean, among other things, we kind of considered the question of how the growth of private enforcement might or should shape the CMA's own enforcement priorities. And of course, the CMA itself does have an important role to play in private litigation with, enhanced rights to be able to participate in those proceedings. But I think it's interesting to think of the feedback the other way. So you can get CMA involvement in private proceedings, but what does this kind of explosion of private proceedings mean for how the CMA should be thinking about how it uses its scarce resources? And I think that's a particularly interesting question then also in the context of the DMCC Act, which is now past Parliament and coming into force shortly. In terms of what the CMA's prioritisation principles make clear is that, they make clear it focuses its efforts and resources on deterring and influencing behaviour that should pose the greatest threat to consumer welfare in the UK, and that the CMA will intervene to protect consumer welfare. So that feeds through in 4 prioritisation principles, which are looking at the impact on consumer welfare and any additional economic impact on efficiency, productivity and the wider economy. Secondly, looking at the strategic significance of the conduct in question and whether it's in line with the CMA's broader strategy and objectives to bring a case. Thirdly, looking at the risks, so whether the case is likely to succeed or if it's likely to fail, and therefore whether that achieves a good outcome and is a good use of public resources. And its 4th criteria is resources themselves. So I think the growth of the CPO regime really is a very clear relevance when we're thinking about how the CMA is best placed to act. And I think it creates a new dynamic now that there's so much more private enforcement to think about what is the comparative advantage that the CMA has over private litigants, and how can it use that advantage to best achieve its aims of promoting consumer welfare in the UK. And I think Grigoris, I completely agree with you that, you know, the potential availability of litigation funding is a very important factor that feeds in, but I don't think that should be kind of the end of it, because like you say, you know, the incentives that litigation funders might have to bring claims might not always align with consumer welfare and with what's in the interests of, not to suggest that they're not pursuing aims which may ultimately benefit consumers, but in terms of the cases that they choose to bring, those may not be the ones that are of the greatest public importance. They are naturally likely to be the ones that have the biggest payouts available, and so I think that means that it's still a very important role for the CMA to look at how it uses its resources in order to kind of pursue its priorities. I mean, to my mind, if we go beyond litigation funding, and as we outline in the paper, I think there are a number of other factors that should shape the CMA's own administrative priorities in enforcing CA98, and especially in the context of now having this whole new set of powers in the DMCC, in particular its new strategic market status regime, where the CMA will be able to designate tech companies as having strategic market status, and where it has designated them, it will write for them, or in fact in parallel with the designation, will write a code of conduct which will regulate the behaviour of that firm. Critically, and I think this is a big difference with CA98, all of the decisions, other than the decision to impose financial penalties under the SMS regime, the appeals from those are on a judicial review standard rather than on a merit standard. And so I think what that means, and it's an important factor to think about when you think about how the CMA should use its resources, is I think that really is likely to push a lot of the enforcement. If you think about the CMA's enforcement docket the last few years has been majority cases against big tech. Actually, in a world where the CMA has designated those firms as having strategic market status and has codes of conduct which it runs for those firms, I think there are really strong incentives for the CMA to use the strategic market status regime rather than to use the Competition Act in order to pursue conduct which they consider harms the public interest, because it's a much more flexible regime, and because they face a lower standard on appeal. I mean, the idea is that will make the regime, you know, faster and reduce appeals. I think we have different there are different opinions on that, including mine, which is that JR is not necessarily faster, because if the court overturns the CMA, you get the case sent back to start again from the beginning. But I think that's a really important factor as you think about, you know, where the CMA should be using its resources and which of its tools, now it has these additional tools, it should use. And in particular, where it chooses in the context of the DMCC, you know, the CA98 investigations are expensive for the public purse. They are very slow. They are often appealed up through the courts. So I think that does put a lot of pressure on the CMA in choosing which cases to bring. So in our paper, we suggest a number of factors beyond the potential availability of litigation funding, which, as I said, will sometimes be relevant, but I think is not the end of the story, about where the CMA might still be well placed to act. So to my mind, there are a number of factors that might play in. The first is there are cases where the CMA will have a significant information advantage over, in particular for non-public infringements. So the CMA has really significant information gathering powers, including obviously the power to conduct dawn raids. It can require people to produce documents. It's getting even more information gathering powers under the DMCC. And by contrast, private litigants are often at a significant disadvantage in terms of access to information to substantiate the claim. And, you know, that's why we have the very long process of disclosure, and indeed part of the reason why, you know, there's a relatively permissive approach at certification. But I think that's an important factor, in particular where there's conduct which is not public, but which the CMA is aware of. The CMA has much stronger powers to gather information and to put together a credible case than a private litigant might. The second area where I think there's, and this is very important in the context of the DMCC, is I think there are issues which are cross-regulatory and where there is a real benefit to coordination between regulators, and the CMA is well placed to do that. So, you know, the obvious and kind of poster child for this is the Google Privacy Sandbox case, where the CMA worked hand in glove with the Information Commissioner's Office over those commitments. Obviously, there have been recent developments in the last month or so on the Privacy Sandbox case, which we probably don't have time to get into now. But I think that is an interesting example, you know, and there are other cases as well where there might be conduct which raises competition concerns, but also touches on other areas of regulation. The CMA is really well placed, and actually under the SMS regime, there's kind of enhanced consultation with other regulators, and the CMA might be much better placed than private litigants to deal with those cases more flexibly. The third area is where there's cases that require interventions beyond fines. So commitments, which can be, you know, we've just touched on the Sandbox case. And in particular, under the SMS regime, there's a much broader toolkit to take both conduct, you know, impose conduct requirements, but also to take pro-competition interventions where there are structural issues in the market. So I think there's still a big role for the CMA there. The kind of fourth area, which is the kind of penultimate area, is, and touching back on Matthew's paper, is where there is a strong interest in specific deterrence of the individual firm, you know, because the private litigation regime is focused on compensation. You know, there will be cases where there is a really strong interest, where there's conduct that should be punished for the sake of being punished and deterred. And I think the CMA is uniquely positioned there, much better positioned than private claimants. And then finally, not to forget, but going just beyond slightly the scope of competition law itself, is of course consumer law. As we discussed at the top, you know, there are a number of these cases that are currently brought as class actions under the Competition Act, but where many of the issues that they touch on are really much more consumer elements. A really important element of the DMCC Act is that the CMA is getting significantly strengthened consumer law powers. So the CMA will, which has so far needed to go to court to prove a consumer law infringement and has had no power really to impose fines. Now the CMA is getting power to take administrative decisions about infringements of consumer law, and to impose fines of up to 10% of global turnover. So on a par with the fines that can be imposed for breaches of competition law. And I think, you know, stepping back, if you think about all the different tools that the CMA has, it has CA98, it has its consumer law powers, soon to be much stronger. It has the strategic market status regime, very flexible, lower standard of judicial scrutiny, and designed to be able to move quickly. I think, you know, collectively you can see that the toolkit the CMA has is so much broader than private litigation. I think it means the CMA is obviously going to play a really, really important role going forward, but that role is going to change from what it was 5 years ago, and I think rightly so.
Many thanks indeed, Verity. Let me ask Grigoris and Matthew to reflect, or maybe ask questions or comment. Grigoris.
Yeah, I mean, this ties very well with my own research and the paper I just presented. I think I agree fully with a list of reasons where the CMA's intervention might be more welcome than other cases. I guess, again, taking stock of my paper, I would just, if we had a more developed, let's say, voluntary redress scheme, or a voluntary redress scheme that's used more by the CMA, it could be another reason for, you know, promoting the CMA's role as opposed to the private enforcement in certain cases. That is, if there is an easy way for the CMA itself to use the fines to award compensation, or to agree a voluntary redress scheme with the alleged infringer, that could be another reason for why the CMA would be best placed to intervene in a case. So yeah, apart from that, I have nothing else to add.
Thank you very much, Matthew.
Yes, I think, well, firstly, really enjoyed your paper, Verity, and even though I think you said it might be a year or so old, it, you know, stands the test of time, and it, you know, all the points seem to, you know, really be so true today. I think not so much a question, but more so an observation. On this subject of perhaps who should be spearheading, where these claims are coming from. I think what I've got out of speaking to you all is I don't think there should necessarily be one focus. It's just each of these different areas have a role to play, and I think you can see the pros and cons. For all of them, and actually just one point, Verity, you mentioned there about the cost for the public in some of these CMA investigations. It isn't one that's always thought of, and I think yes. For example, going on the funding point, whilst funders will take cases for various reasons, it's not to say those cases aren't important. The point is that if there's damage and if there's been loss, that competition law needs to address all of those instances. So it does seem to me that we want to find this really good balance where everyone is filling the gaps, as required. I think just talking about the consumer law point, and I think it is good to see the DMCC Act now gives the CMAs further powers, and in some respects, like competition law shouldn't be stretched to the extent that or outside its scope. And I think the consumer law powers will help deal with those issues where competition law isn't the right forum. I suppose one final point that I was just interested to hear, maybe Verity and Grigoris' take is in the DMCC Act, you can now, it seems there's a power to award exemplary damages. I was just wondering if there's any observations on that. At least in my view, it seems such early days that I haven't necessarily got an idea as to what that's actually going to mean in practice. But I was very curious to know if either of you have thought about it yet.
Thank you very much. Verity?
Yeah, I mean, obviously it potentially significantly increases the liability that there could be. But I think, as you say, Matthew, we're kind of far. It only applies to infringements which take place after the Act comes into force, which hasn't even happened yet. So I think, from my perspective, it's certainly another thing that we will be kind of warning clients about. But I think we need to see how it evolves and whether it is confined to a really small subset of cases, or whether it's something that becomes more commonplace.
Great, thank you very much. I propose we finish with your recommendations to students. This area is very exciting and so much is going on. Maybe you have some helpful suggestions which would somehow optimize their limited resources, getting them focused or straight to the issues which are of direct relevance, the most important, of the highest importance, etc. Grigoris, let us start maybe with you.
Yeah, I think something that students, especially as they start out, might find interesting is that while this area might sound very technical and complex, it's very interesting how it ties really well with very broader questions of the aims of competition law, or even the aims of damages, right? So just if we take note of what Matthew said about whether we can award restitutionary damages here, it has to do with what does our private enforcement system aim to do exactly. And again, it shows that this area is very crucial as to the development of private law as a whole in the UK, not just in competition law, competition damages in the narrow sense. And it might tie with very interesting issues. Again, me talking as academic of political economy, of where are we moving as a legal system? Are we moving towards a legal system that's more reliant on private enforcement and that understands litigation or tortious litigation as a method of achieving public policy or enacting public policy, as opposed to awarding compensation? And where can we draw the line between private and public? And I think those questions are very interesting for students to think about. And yeah, I would encourage them to do so.
Thank you very much, Grigoris. Verity?
Yeah, I mean, completely agree with everything Grigoris said. And I think this is such a, the thing that drew me to competition law in the first place is that I feel like it really sits at the intersection of law, really interesting black letter law, constantly evolving, also of economics, but really also there's a political element to it as well. And I think what we've seen over the last, certainly, especially in the digital space, is we've seen that political element loom ever larger, and it makes it a fascinating area. But I think it also means that it's an area where there are so many developments, it can feel really difficult to keep up. I mean, my own experience, I went on maternity leave for a year and I came back and I felt like I'd missed 5 years because so much had happened. Not that I read nothing while I was off, but I didn't read as much as I normally do. And so I think the advice that I always give to people kind of starting out in the area is it's very easy to feel overwhelmed. Don't feel that you need to understand everything. Pick 1 or 2 particular topics that you think are interesting. Actually learn them back to front, and then just follow them as they evolve. And over time, especially if you become a practitioner in the area or indeed, an academic, once you have that base on one area, you find actually it's quite easy. It's like building, 1 brick at a time of building up your knowledge. You have to do the work to form the base, but then you just, each new news story you see, you're just kind of putting another brick on top of your knowledge. And the longer you stay in the area, there become more and more topics on which you have that foundation where you can lay the bricks on top. So I think that's kind of my advice, is don't feel overwhelmed. Don't feel like there's so much going on here that you can never possibly follow it. That is true. I think when you're starting out, you can't expect to know everything. No one expects you to know everything. But actually over time, as you stay in the area, you can build that foundation and continue to build on it, actively build on it, and pursue the areas that are of most interest to you, and then it doesn't feel like work.
Thank you very much, Verity. Matthew?
Yes, I mean, I can only echo Grigoris and Verity's suggestions there. And in particular, I think, when I look back to the very first, and this was just by happen chance, work experience I did was a mini pupillage shadowing a barrister who happened to be working on an opt-out claim. And I hadn't really come across, or at least thought about competition or outside of, hearing about it. But it was really that intersection, as Verity says, of black letter law, but then also the economic evidence that absolutely intrigued me. But then I was also just quite interested in this notion of class actions, which is of course exclusively reserved at present to competition law claims. And I think it was, for me at least, it was really focusing on that one quite small thing in this massive area of competition law that I just kept thinking about. So I completely agree that I think it can seem utterly overwhelming because there's so much material. But I think if you just pick an area that interests you, it's amazing how far that can go. And also you start to see things down the line that just all start to align and chime, and you're kind of like, oh, I understand that now because it relates to this, and it's a really great way of getting to the getting to the end, or not the end, because it's by no means there at all, but at least understanding things. And I suppose just as a useful tool, but one thing that I think might be quite useful is, on the Competition Appeal Tribunal's website, they obviously have all these cases which seem incredibly complicated because they'll have orders and judgments. It's quite hard when you initially get into it to really navigate it all. But I think just going on there and starting to look through some of these cases and just picking one that might interest you and maybe following it, one will give you a bit of an idea of the procedural context of how these things develop, but 2, you'll also start to read how competition law is actually applied in some of these judgments, and I think that could be as a resource to refer to. I think that's quite valuable. But yeah, outside of that, I think it's a great area to get stuck into.
Yeah, absolutely. Grigoris, Bacharis, Verity, Egerton-Doyle, Matthew, Tweddell, thank you very much for this very detailed, very informative, amicable, and thought-provoking conversation. It was a pleasure to see you.
Thank you, Olive.
Thank you so much for having us.
Thank you, everyone.
Thank you.